Vishnu,
Yeah.
wait a second. Let's people join. Like 17 are in, right? Two
Hmm.
or three might join 1 or 2 minutes. Okay, let's wait for a little while more. Like six, 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 seven. It's okay. We can probably wait a little more.
Sure, man.
Um, I mean, it'll be a real pain for you again to go through the same sections if people start asking again later on.
Yeah, 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 yeah. And I'm so nervous, man. Yeah. So we'll go slow and steady. Fantastic. Right then, because the starting is quite simple because I'll be redefining all the mortgages only, something that we already know. Okay. So section 58 defines what a mortgage is. Okay. Clause A just tells you what a mortgage is. And what is a mortgage? Because I didn't know what a mortgage was. Where this guy borrows money, Virat Kohli borrows money from Rohit Sharma, and in exchange, he mortgages his property. Okay. The property is the guarantee he's giving, and Rohit Sharma gives him money. Okay. So what is a mortgager and mortgagee? Because you keep getting confused, right? Mortgager rhymes with borrower. Okay, internalize this completely because you're going to refer to this term multiple times. Mortgager, borrower. Mortgager borrows money. Mortgagee lends money. Okay, so Virat Kohli borrows 50 lakhs and he mortgages his house, and Rohit Sharma gives him the 50 lakhs, being the mortgagee. Okay, and a mortgage document must always be registered unless it is less than 100 rupees. When will anyone borrow something less than 100 rupees? Correct, and mortgage a property. So a mortgage document always has to be registered so that it's official. All right. Before we get to the types of mortgages, I just want to give a quick introduction to foreclosure and sale. We'll get to it again in section 67, but just an idea of what it is. Foreclosure is a legal proceeding to terminate the mortgage agreement. Okay, to completely close it. That is called foreclosure. Okay, and what is sale? Suppose Virat Kohli has been unable to pay the 50 lakhs back. So how will Rohit Sharma get his money back? He will sell the property. Okay, so that is called selling, and you can do this by suit for foreclosure or sale. Section 67. We'll get to it again. Okay. So what are the types of mortgages? Simple mortgage. Okay, this is the simplest one where he takes money, he mortgages his house. So there's an encumbrance created on the property because it's mortgaged. But I want you to note that without delivering possession of the mortgage property, that means Virat Kohli will continue using this house or he'll continue living in this house. Rohit Sharma doesn't get the house, only it's mortgaged. Okay, and he binds himself personally to pay the mortgage money. You'll understand what this means later on. Okay, so in a simple mortgage, he takes 50 lakhs, he mortgages the house, but he remains in possession. Okay, in case Rohit Sharma cannot recover his money back because Virat Kohli is unable to pay it, he will file a money suit under section 68 1A or under section 67. He'll sell the mortgage property. Okay, we'll understand this later. Just an introduction to the concept. Okay, so what are the main points in simple mortgage? It's personally binding. Remember this. The mortgagee is not in possession. The lender is not in possession. The mortgager remains in possession. Okay, there's no right to foreclosure in this. There's only right to file a suit for sale. You'll understand this later on. Okay, just remember this. There's no foreclosure, only right for sale. And the suit for sale you'll have to get a decree from the court, a primary preliminary decree and a final decree from the court. Basically, everything has to be done legally. Okay, can't do this outside the ambit of the court. Second one, mortgage by conditional sale. So in this, what happens? He borrows money, but in this, he's not just mortgaging the property. He ostensibly sells the mortgage property, as in he makes Rohit Sharma a temporary owner, an ostensible owner. And what does he say? In case Virat Kohli is not able to pay it back, he tells Rohit Sharma can become the permanent owner. Okay, that's what he's saying. He's saying, I will conditionally sell it to you. And if I pay back the mortgage money, if I return the 50 lakhs, then I get the property back. And if I'm unable to pay it, In that case, you become the complete owner. Okay, so that is what mortgage by conditional sale means. Okay, so the court in this case, in mortgage by conditional sale, you can file a suit for foreclosure. Okay, because to terminate the mortgage agreement so that Rohit Sharma can become the complete owner. See, I put R over here, so he becomes an ostensible owner. So what are the main points in mortgage by conditional sale? The lender, the mortgagee, becomes an ostensible owner. Upon any default in payment where Rohit Sharma is unable to pay, the mortgagee must file a suit for foreclosure under section 67. Okay, and once the court passes the final decree, only then the mortgagee becomes the owner. So the court has to act. You can't do it outside the court. It is not personally binding. Remember, simple is personally binding. And mortgagee is not in possession of the property, and the mortgagor continues to remain in possession. Okay, once he's unable to pay, then Rohit Sharma becomes the owner. Then he can throw Virat Kohli out. Okay. And you file suit for foreclosure. Right to sale is not needed, correct? Since it's already been ostensibly sold. So he doesn't need to file a suit for sale. Third type, usufructuary mortgage. Okay, this is the most interesting type where he's not mortgaging some ordinary property. Okay, it's an income generating property, such as an orange orchard, an airport, a highway toll, a pond where you can fish, where the mortgagee, he uses that property to recover the mortgage amount. Okay, let's say he borrows 50 lakhs. Rohit Sharma gives him 50 lakhs. And Virat Kohli gives him a cinema theater that he owns, an Inox or PVR cinema hall. Okay, and Rohit Sharma, collecting the ticket money by playing movies here, he recovers the amount 50 lakhs back over 10 years, 20 years, whatever the period is. Okay, so in this case, the mortgagor delivers possession. In the other two, we saw the mortgagor remains in possession. Here is delivering the possession. Okay, and he binds himself not personally. He binds himself to deliver possession. Okay, so he's not binding himself personally even in this condition. Okay. So what are the important points? The mortgagor is required to put the mortgagee in possession of the property. Okay, so mortgagee obviously, right, he has to use the property to get his money back. And once he gets his money back, the property will go back, correct? Okay, so any immovable property and attached to the earth components can be part of the usufructuary mortgage. So you can't do this with movable property, only with immovable property. Okay. In case of non-realization of the debt money, let's say Rohit Sharma gets this movie theater and suddenly COVID happens and no movie releases for like 5 years now. Nobody's coming to movie theaters. So how is he going to get his 50 lakhs back? Huh? He can't do anything because he can't even sell this property. What happens here? In case of non-realization, the mortgagee cannot file a suit for foreclosure or a suit for sale. It is the only mortgage where the mortgagee has no legal recourse. He can't do anything. He suffers a 50 lakh loss. Okay. So there's no right to file suit for foreclosure. And Matilal sir gave a very beautiful quote. He says, if the mortgagee is callous, as in he's careless in his charge, and is unable to realize his money due to no fault of the mortgagor, court will not give any right for foreclosure or sale to the mortgagee. Okay, the mortgagor has a right to inspect the account books to monitor the realization of the mortgage money by the mortgagee. As in, each month Virat Kohli can go and see the account book to see how much Rohit Sharma has made that month. So when he completely realizes it, the property comes back to Virat Kohli. All right, very simple. And something that Avinash pointed out in the jurisprudence during the jurisprudence exam, section 62, which I didn't know about. Basically, what did we say? The mortgagee has no legal recourse, right, to get his money back. But the mortgagor, till he pays back, till he pays the remaining amount, till he pays the mortgagee the mortgage money or the balance thereof, the mortgagee can withhold the property with himself. Okay, that's what I want you to know. I want you to know that till, look, Rohit Sharma can't do anything till to get the money back. Okay, but till Virat Kohli pays this amount, Rohit Sharma can hold on to the cinema theater for eternity, perpetuity. Let's not say eternity. Okay. So that's one advantage this guy has. And you see that rights matrix I explained right in the group where he goes from a position of disability to power and he goes from immunity to liability. So that's what happens. Don't worry about this. This is just extra information. OK, sections of then we come to English mortgage. OK, English mortgage is a very colonial era. It's a old type of mortgage. OK, and it doesn't exist today. Basically, in this mortgage also, the mortgagor binds himself personally to pay the mortgage, similar to simple. And he transfers the mortgage property absolutely to the mortgagee. Okay, in conditional mortgage, he does it conditionally. Here he does it absolutely. What does that mean? In this case, when he takes 50 lakhs, Virat Kohli makes Rohit Sharma the owner of the property. Okay, and in case he is able to pay the 50 lakhs, then the property will return to him. And in case he doesn't do it, Rohit Sharma does not have to go to court to file a suit for sale. He automatically becomes the absolute owner of the property. So it's a very old law. It's a colonial era law. And the mortgagee can directly sell the mortgage property because he's already the owner, bypassing the court without legal intervention. This is English mortgage, correct? Moving on, it's personally binding. The mortgagee is again not in possession of the property. The mortgagor remains in possession, and the right to file suit for sale doesn't exist. Okay, because he doesn't have to go to court because he's already the absolute owner. Okay. What is the next one? Mortgage by deposit of title deeds. This is the most common type of mortgage. Okay, basically when you take an educational loan from the bank, what do? You give them your title documents, correct? And then they give you a loan. You don't have to go deliver the property. It's not like usufructuary mortgage. It's not conditional, say nothing. So what is important is when you're delivering this title document, the documents of your house to the bank, and the bank gives you 50 lakhs, mere delivery is not enough. Okay, you need to convey an intention with an intent to create a security. Okay, you need to deliver the documents and you need to convey an intention that you're doing it to create a mortgage by deposit of title deeds. Okay, and what does it say here? Where a person in any of the following towns, and they list out a list of towns over here, right? So this means this deposit of the title deeds has to happen in one of these towns, in these specified towns. As in, the documents have to be handed over in these towns. And let's see what it exactly means. So it's the most commonly used type of mortgage in India. All bank loans are mortgaged by deposit of title deeds. The mortgagee is again not in possession. The mortgager, the borrower, remains in possession. A right to file suit for sale exists. There's no foreclosure. You have a right to file suit for sale. The bank will file a suit for sale to sell the property in case you're not able to pay it back. Okay. The title holder, by passing on the title document to the mortgagee, will create a charge. So the mortgagee has a charge now with the help of which he'll be able to file a suit for sale. Okay. A mortgage by deposit of title deeds does not require a registered document. All right. Coming to some interesting facts in England. Okay, in English common law, it's called equitable mortgage, and in England, a mere transfer of the title document is enough. Okay, me just if I was in England and I give my title documents to Krishna, okay, I don't have to give him my intention. Just me giving my title documents is enough to create a mortgage by title deposit. Okay. So without express intention, it will create the mortgage. But in Indian law, okay, there needs to be a delivery plus intention. And what does intention mean? It has to be explicit express intention. For a mortgager, the borrower, for the mortgagee to prove the intention of the mortgager, I have to reverse it. Okay, I'm sorry, it's wrong. For the mortgagee, the lender to prove that the mortgager has intended it, it'll be best if you can get a memorandum made. This is what Sir said. You need to get a memorandum made, saying that that guy is explicitly signing a document saying that I am giving it to you with the intent of creating a mortgage by title deed, correct? So what else? The property may be anywhere. Okay, I can have it in some forest in Northeast India, but the delivery of the documents, where I'm handing over the documents, it has to be in the specified towns mentioned in the section, correct? And these specified towns, the government has amended the act to include all the towns in India. So basically, every single town in India, the state governments have extended to all the towns in India. So it has to happen in a specified town. Okay. And basically all mortgages over ₹100 have to be registered. Cool. So this is a sample mortgage memorandum that Sir showed in class. It doesn't have to be a registered document. It doesn't have to be stamped paper. Okay. So if you can get this memorandum made when you give a mortgage by title deed, that means you're safe. Okay. Because it proves intent of the mortgager. And then he gave two cases. And then this interesting case, KJ Nathan versus Maruti Reddy. There's a rich landlord. Okay. A rich guy. And he has a manager. And the manager manages all his affairs. Correct. And the manager, he obviously has the power of attorney. So the manager, he has all the property documents of his boss, correct? Because he's managing all the affairs. Now suddenly the landlord runs into some kind of debt, some financial trouble, and he borrows money from his own manager. Okay. And he's not able to pay that back. And when he borrows even more money, okay, the landlord tells the manager, look, you already have my documents, correct? You keep it and you make this a mortgage by title deed. Okay. So was this intention? Can you call this as intention? Yes. Okay. Because he has given express intention that he wants to create a mortgage by title deed. So mortgage by deposit has been created. So after that, he refused to pay the money back to the manager and it went to court. Okay. The landlord, he accepted all the facts. He said, I've done all this. Yes, I'm not disputing that. But what he said was no formal deposit was made. Okay. Since the manager already had the documents, he never got a chance to make a deposit in a specified town. He said the manager was supposed to return the documents to him temporarily. And then the landlord had to make a redeposit and delivery with the intention. Okay. Therefore, since no delivery was made, explicit delivery was made, the mortgage by deposit was not even created. He said no mortgage by deposit was created. What did the court say? The court threw his argument out. The court rejected the plea of the landlord. It said the delivery was made in substance. Okay. So don't try and fight on a technicality, and the mortgage was created. Okay. If just one more thing that Sir said, in case you have not made a memorandum here, okay, in case no memorandum exists, then the court under section 114 of the Indian Evidence Act, where it will consider reasonability of what has happened and intention conveyed, delivery made, it will take a ruling based on section 114 of the Indian Evidence Act. Okay. So let's assume Harry Potter, he mortgages Hogwarts Castle to Voldemort. Okay. He takes 50 crores and he delivers the title documents to Voldemort. Okay. And Hogwarts Castle is in England. So in this case, what happens? Him giving the documents is enough to create a mortgage by title deed, correct? Because in England, mere delivery will be enough to create a charge. All right. Assume that Hogwarts Castle is in Jaipur in India. Okay. So in this case, Just delivery is not enough. You need to prove intention, correct? So Voldemort will have to prove the intention. So how can he do that? He can either hope that under section 114 of the Indian Evidence Act, the court could find some scope of presumption of intention of the depositor title deed. But it's very shaky, okay? And it depends on how the court is. Or he can make a memorandum while accepting the deposit. He has to make a memorandum with Harry Potter, all right? So hence, instead of relying on section 114, it is better to always create a memorandum to ensure a guaranteed delivery of intention, all right? Moving on to the last type of mortgage, okay? So we saw simple, conditional sale, usufructuary mortgage, English mortgage, title deeds, and now anomalous. So basically any mortgage which is not simple, mortgage by conditional sale, usufructuary, English, or mortgage by deposit is an anomalous mortgage. So it's a very unique type. Something that's not the other five is an anomalous mortgage. And the parties decide the terms of the mortgage. Okay, it's very unique. It has to be registered, compulsory, and acknowledgement of repayment of money must also be registered so that no encumbrance exists, so that any future person can buy it without trouble. It may or may not be personally binding. Since the parties decide the terms of the mortgage, it may or may not be personally binding. All right, very simple. I made a table so that it's easier to understand. So basically suit for foreclosure and suit for sale. So basically based on this table, can you see that suit for foreclosure exists only for conditional sale, mortgage by conditional sale, and anomalous depending on the agreement. Okay, suit for sale exists in simple mortgage, English mortgage, and title deeds, mortgage by title deeds, okay, where the property can be sold to recover the money. Usufructuary mortgage, you can note that neither of these exist because there's no legal recourse to get the money back. All right. Anomalous, depending on the agreement, you can either have suit for sale, you can either have suit for foreclosure, or you can have both. All right. And where all is it personally binding? In simple mortgage, it's personally binding. In English mortgage, it's personally binding. And in anomalous, it depends on the agreement. You'll understand why we refer to this later on. Okay. Because you can file a money suit only if it is personally binding. All right. All right. Was it clear? Like, are you guys following? Am I going too fast, too slow? Anybody? Bhuvan, Krishna?
You are going at a perfect pace, man.
All right, guys. Going on, section 60, okay? We saw section 58. Section 60 is right to redemption. And redemption is an equitable right. What does redemption mean? It means the right, I'm the mortgager, I'm the borrower. It's my right to repay the mortgage and to take my stuff back. What all stuff do I get back? I get my title documents back. I get the property back if it has been put in possession, and I get a registered acknowledgement of repayment. Okay, this is called redemption. And the right of the mortgager to redeem the mortgage is called as the equitable right to redeem. Okay, it is sacrosanct. Remember this. What does that mean? It cannot be taken away by contract. So when I'm making a mortgage agreement with Avinash, okay, and I make a deal like I'm the mortgagee, I'm giving him money, and in the contract I put that Avinash will not have the right to redemption. Okay, I cannot take it away. It will be struck down. Okay, any clause attempting to take away the right of redemption will be struck down. It's called the clause on the equity of redemption. Okay, it will be struck down by court. Only a decree of court for foreclosure of sale. Only when the mortgager, only when the mortgagee, only when I file a suit for foreclosure of sale and the court agrees, only then the right of redemption of the mortgage will be shut down. Otherwise, it is sacrosanct. It can never be taken away. Okay. All other sections, section 67, 68, which you will see now, they can all be taken away if mentioned in the mortgage agreement. Only section 60 cannot be taken away. All right. So what are the important points? Right to, it's basically understand it as a right to repay the mortgage and a right to reclaim the documents and deeds upon repayment of the mortgage debt. This is redemption. Understand this, internalize this completely, okay? Because it's a very fundamental concept that you're going to use later on. It's a right to repay the mortgage and a right to reclaim the documents and deeds upon repayment. All right. If the mortgagee tries to avoid getting repaid, some harkat he does, like last few installments he doesn't want to get paid, okay? Because I don't know, he just wants to keep his hold over the mortgager, and he does not comply with acts necessary to remove the encumbrance on the property. Okay, then the mortgagee can go to court and he can file a suit of redemption. Okay, and the court will grant it to him, and then the mortgagee will have to accept the payment. Okay, the mortgager cannot file the suit for redemption until the period of mortgage lapses. That means there's a due date, right? If I take a mortgage amount, like I take money and I give my property, right? There's a due date within which I have to pay the amount. Before the due date, I can't file the suit for redemption. Only after the due date. If I file it before the due date, the suit will be premature. Okay, and in extraordinary cases, where it's unconscionable, the situation, and the court really feels they have to step in that case, the court might entertain it, but otherwise the suit is premature, it will be struck down. Okay, redemption suit can be filed anytime after the due date by the mortgagor for up to 30 years. This is the limitation period. For 30 years after the due date, I can file redemption suit. Okay, if the mortgagee doesn't get paid by the due date, the mortgagee can take the mortgagor to court with a suit for foreclosure or sale. Like we discussed, section 67, he can file a suit to shut down the redemption right of the mortgagor. Okay, when the decree is passed, the right of redemption of the mortgage is shut down. Exactly this point. Only a decree of court for foreclosure or sale can shut down the mortgage's right to redemption. Okay, very simple. Now we come to section 67, suit for foreclosure and sale. Okay, based on the table we saw, right, only conditional sale has foreclosure, and suit for sale comes in title deed, simple mortgage, English mortgage, not English mortgage, anomalous mortgage. Okay, so section 67 are remedies for the mortgagee in case the mortgagor is not able to pay. These are the remedies. Okay, he can file a suit for foreclosure and sale. The limitation period for the mortgagee to file suit is 12 years. So 12 years after the due date of the mortgage, I can file a suit for foreclosure and sale. Okay. The limitation period for the mortgagee to file suit for foreclosure. Remember, they're two different things. Okay. Foreclosure is to terminate the mortgage agreement. Sale is to sell the property. Okay. So the limitation period to file suit for foreclosure is 30 years after the due date. And here it's only 12 years. Okay. So in case something I forget or about the mortgage or something happens and I'm rendered incapable of doing it, and after 13 years, I can't file suit for sale. After 31 years, I can't file suit for foreclosure. It's over. But basically, I think Matilal sir said that all limitation periods have been put on hold for now. So limitations don't even exist practically right now, presently. Okay. Section 67. Okay. The suit for foreclosure and sale. They do two things. It shuts down the right of redemption of the mortgagor, like we discussed. So the right of redemption is taken away. Okay. And it recovers the mortgage debt money by court auction or sale. Basically, the court will auction the property. Whatever amount is there, it will go to the mortgagee so that he can realize the mortgage rate. Okay. Even after the suit for foreclosure or sale is made, it's filed, the court will still offer multiple chances to the mortgagor to repay the money, because the court will always take the side of the mortgagor, always. Okay. Only if the mortgagor fails multiple times will the court give a decree for foreclosure. So it's going to take multiple years. Okay. It's going to take a long time, and it's India, right? So sir told CPC order 34 deals with this. So you can just go through it if you want. Civil procedure code. Okay. So a contract may be made to override section 67. What did I say here? Only redemption is sacrosanct. It can't be taken away. Section 67 can be taken away by contract. Okay. So when I'm making the mortgage agreement and I'm borrowing money, I can take away the right of sale and foreclosure from the mortgagee. I can tell Krishna, look, you cannot sell or foreclose my property. You cannot file a suit for foreclosure or sale. Okay. So I can take it away by contract and the court will uphold it. Okay. Second point, it becomes operative only after the due date and up to 30 years for foreclosure, 12 years for sale. All right. If the mortgagee files a suit for foreclosure or sale, and then the mortgagee files a redemption suit after this, then the mortgagee suit will be stayed by the court. Like I said, right, the court will always take the side of the mortgagor. So first it will examine the redemption right of the mortgagor, and only after that, only if it feels that redemption is bullshit in this case, will it entertain the foreclosure sale suit. Okay, that is section 67. In this case, just look at it like this. Virat Kohli is taking 50 lakhs. He mortgages his house, okay, to Rohit Sharma. What happens now? Virat Kohli, he's unable to pay the 50 lakhs. So Rohit Sharma, he files a suit for sale and he sells it and he gets only 40 lakhs. Okay. What happens to the remaining 10 lakhs? How will he get it back? He can get it back by money suit. Okay. Section 68. Section 68(1)(a) is money suit. Okay. It is to recover any remaining amount or any outstanding amount of the mortgage in case the whole amount hasn't been realized by the suit for sale. Okay. If you aren't able to realize the whole amount by section 67, you file section 68(1)(a) money suit. Okay. And this you can do only where the mortgagor has personally bound himself. And where have they done that? In simple, English, and anomalous mortgage. And anomalous depending on the agreement, obviously, right? All right. So this is suit for sale, section 67. If section 67 and section 68(1)(a) money suit are both filed simultaneously, okay, the money suit will be stayed. It will be put on hold until all the other options are exhausted. And only after the sale, only if there's any remaining amount left, only if any amount is remaining, money suit will come into play. It's kind of obvious, right? Obviously, you can't file a money suit before the property is sold. Only after the property is sold will the money suit come into play. So till that, the money suit will be put on hold. Okay. But I want you to remember this. The limitation period for filing a money suit is only 3 years. Okay. And for sale and foreclosure, it's 12 years and 30 years, correct? So if you don't file your money suit, okay, for more than 3 years, and then you find out that you've still got an outstanding amount of 10 lakhs, then you can't do anything. So it is always better to file the money suit simultaneously. If you're an advocate, you should always recommend your client to file the money suit simultaneously, even if the court puts it on hold, even if it stays it. It is always legally prudent to file the money suit simultaneously. Okay, remember that. So next we come to the next concept where Virat Kohli takes 50 lakhs and he has a property in Shimla. It's a very hilly terrain. It's in the forest and it's worth 50 lakhs. He mortgages that property. Okay, and there's a road in front of the property. Suddenly, the government, due to some protests by some environmental groups, the government decides that that road is harming wildlife, okay, and the ecosystem. So the government demolishes the road, okay. So the mortgage money has been borrowed, the mortgage has been created, but suddenly the value of the property from 50 lakhs, because the road has been demolished now, there's no road existing, the property value drops to 25 lakhs, okay. So there's an unsecured debt of 25 lakhs, correct? 25 lakhs of security doesn't exist on the property. So what will Rohit Sharma do now? Now he's scared, correct? Because now if he tries to sell the property, worst case, if Virat Kohli is unable to pay and he has to sell it, then in that case, how is he going to get the remaining 25 lakhs? He doesn't want that headache, okay? He wants to get this 25 lakhs in security. So what happens here? He can file a compensatory suit, okay? 68(1)(a) is money suit, correct? 68(1)(b), C and D are compensatory suits. If the property value is diminished due to some damage rendering the security insufficient, then the mortgagee may file a compensatory suit, okay? Similarly, the limitation is 3 years from the date of deprivation, not the due date. From the day on which this road got demolished and the property value dropped, he has 3 years to file the compensatory suit, okay? The mortgagee can send a notice. He has to send a notice to the mortgager asking the mortgager to furnish further security. So Virat Kohli has to give one more property worth 25 lakhs, okay, to render the security sufficient. And the mortgager, if he fails to do so, after a reasonable amount of time, this is interpretive of the court, okay? The court will interpret this. The mortgagee has a right to sue for compensation. He can file a suit under section 68(1)(b)(c)(d), okay? It can be filed only before the due date of the mortgage, okay? Because I had asked a question to sir where a very complex situation where can you file it after the due date? And what sir said was, how can you file it after the due date? Because the person doesn't even have money to pay for the property. How is he going to reimburse you for the compensation? So he said, in case the compensatory suit is filed after the due date, the suit will be clubbed. It will be clubbed to the suit for foreclosure or the suit or the money suit, okay? The suit will be clubbed in case it's filed after the due date, but it doesn't happen, okay? So it can be filed only before the due date of the mortgage. The compensation depends on the court's discretion, okay? Whatever the court feels, it will offer it, okay? So in this case, where Virat Kohli has taken money, now Virat Kohli, the property falls, right? It becomes 25 lakhs now. Now he has an unsecured debt of 25 lakhs. Now Rohit Sharma gives a notice to Virat Kohli. He serves a notice saying that Virat, you need to serve the remaining debt of 25 lakhs or I will have to file a suit for compensation, okay? So a reasonable time for the mortgager to respond to the notice is around 3 months. Let us assume it is 3 months, okay? And in that time, Virat Kohli can give some other house worth 25 lakhs, some other property worth 25 lakhs in order for the security to become sufficient. In case he doesn't do that, in case he doesn't respond, then if the mortgagor fails, the mortgagee can file a compensatory suit. Then it will go to court. The court will decide on what the compensation should be. All right. So compensatory suit B, C and D. OK, I just want you to see what the difference is. Just very simple. So in B, any cause other than the wrongful. Yeah.
Vishnu, just one moment. Like the mortgagee like has to first give the notice, then he can file the compensatory suit, right?
Yeah, exactly.
Okay.
And he has to give a reasonable amount of time for him to respond to the notice. And this is not decided. Sir said 3 months could be a reasonable amount of time. That's all. So coming here, what is the difference between B, C and D? In B, okay, in compensatory suit B, 68(1)(b), any cause other than the wrongful act or default of the mortgagor or the mortgagee, where the mortgagor and mortgagee don't do anything and the property value diminishes. In this case, what did the mortgagor and mortgagee do? They didn't do anything, right? The government decided to demolish the road, correct? So 68(1)(b) will apply here. What is 68(1)(c)? Where due to the wrongful act or default of the mortgagor, okay, where the mortgagor does some nonsense and the property value diminishes. In that case, you file 68(1)(c). And even if the sir gave a very complex situation, I don't think it's coming. So when the mortgagor does something, let's say some bullshit where he only files a petition to demolish this road, then maybe you can file 68(1)(c) in this case. Okay. Coming on to 68(1)(d). 68(1)(d) applies in anomalous mortgages, a very specific clause. Okay. Let's see what it says. So 68(1)(a) money suit is specific only to simple English and anomalous, where the person personally binds himself. All right. 68(1)(b) and 68(1)(c) are mortgage neutral. What does that mean? They apply to all mortgages. Okay, it doesn't matter what mortgage it is. Basically, if there's a diminish in the security, you can file 68(1)(b) and C, but it's before the due date. Okay, 68(1)(d) is specific to anomalous and usufructuary mortgage, something I missed. Okay, just remember this. Okay, so Harry Potter takes 50 crores from Voldemort and he mortgages Hogwarts Castle, which is worth 50 crores. And let's say the due date, this was done on 1st January 2021. It's done in 2021 and the due date of the mortgage is 2030. Okay. For some reason, they ban wizarding schools or something and they put higher taxes on wizards. Okay. And so the property value of Hogwarts Castle drops to 30 crores because the taxes have increased on magical institutions. So its value is only 30 crores when it was supposed to be 50 crores. So Voldemort is falling short of 20 crores now, correct? In 2022, 1 year later, this has happened. Okay. In 2021, the mortgage was created. It's due on 2030. In 2022, the value dropped suddenly, all of a sudden, due to no act of the Voldemort or Harry Potter, right? So in this case, the limitation period for the compensatory suit is 2025, correct? From the date of deprivation, he has 3 years. So from 2022, he has 3 years to file the compensatory suit. Okay. So in 2024, he sends a notice to Harry Potter because he's still within the limitation period. And he tells, look, Harry Potter, you need to submit something worth 20 crores or this is not enough. Okay. So 3 months are over. Then Voldemort files a compensatory suit under 68(1)(b). All right. So what happened here? Yeah. So what all can Voldemort do? Voldemort cannot file a suit for foreclosure or sale. Section 67. Why? Because it's 2024. You can file a suit for foreclosure or sale only after the due date. Only after 2030. Correct? He can file suit for foreclosure or sale. Or a money suit. Even a money suit can be filed only after the due date. Okay? And in case he files either of these suits, 67 and 68(1)(a), the suits will be premature before the due date. Okay? The court will throw them out of the window. Okay? So only the compensatory suit is possible. Moving on.
Vishnu?
Yeah.
Mortgagee will file a suit or what? Yes.
Mortgagee, yes. Mortgagee, the lender.
Okay.
Yeah. Okay. 69, okay? This is a very small thing. Don't break your head over this. Is it possible for the mortgagee to bypass the court and sell the property if, yeah, can he sell the property without going to court, without filing a suit for sale, without filing 67, section 67, suit for sale or foreclosure? Can you sell the property? Didn't I already mention in English mortgage, you can do this. In English mortgage, since you already create an absolute owner, you can do it. You can sell the property without going to court because you're already the absolute owner. But according to section 69, there are certain restrictions. Okay. And if you can follow all the restrictions, you can do it in other kinds of mortgages also. So according to section 69A, the mortgage must be an English mortgage, and all the other provisions mentioned in 69A, if they are fulfilled, then you can sell the property by bypassing the court. Okay, it's not discussed in class, so don't break your head. Sir explained something where a SURFACE Act was passed by Parliament, which enables the bank, if you have taken a loan from the bank can sell your collateral without court intervention. Okay. And for this to happen, the outstanding amount of the debt should be at least 20% of the total debt. It's very confusing. Don't break your head. If you have taken 1 crore from the bank, okay, and the balance debt is little more than 20 lakhs, that means the bank can sell your collateral without going to court. That means if you're paid 81 lakhs, if you're paid more than 80% of the debt, then the bank can't do this. Only when the remaining amount is more than 20 lakhs, more than 20% of the total debt, the bank can enable SURFACE Act. Okay. It's not going to come.
Vishnu, can I just repeat that once again?
Yeah. So according to SURFACE Act, if you have taken a loan from a bank, okay, the bank can sell your collateral without going to court, without filing section 67, suit for foreclosure sale, they can sell your collateral. And they can do that only when the remaining outstanding amount is at least 20% of the total debt. What does that mean? Just forget the 20% part. If you have borrowed 1 crore from the bank, okay, and you have not been able to pay it back, obviously, right? And if the remaining amount is even little more than 20 lakhs also, then the bank can sell your collateral. Okay. If I owe 30 lakhs to the bank, then the bank can sell my collateral without court intervention. But if I paid more than 81 lakhs, 80 lakhs, that means less than 20 lakhs is remaining, correct? Less than 20% of the debt is remaining. So if I paid 81 lakhs, then the bank can't do this, since at least 20% of the total debt has to be remaining. Okay. So in a debt of 1 crore, if I paid anything more than 80 lakhs, then the bank can't sell my collateral without court intervention. This is not coming. Okay. Sir gave extra information, so don't break your head on this. Just remember that in English.
Another thing is there, Vishnu Samrat here.
Yes,
another
sir.
thing is there, other than that, SURFACE Act is also there, which is pertaining to banks. But all of you should remember also that section 69 can also be applied in specifically only for English mortgage. And where there actually, this is the process by which for English mortgage, you are bypassing the court. You do not have to go to the court at all. So this is complete waiver. So this is a very vital point. Yeah, Vishnu.
Fantastic, sir. Perfect. Moving on, I want you guys to forget everything you've learned, okay? Because we're getting into the complex part of mortgages now. Very complex, okay? So I'm going to ask 2 questions. Can you mortgage a leased property? I don't own the house, okay? I've leased a house from Anirban. I've taken a house on lease. Can I mortgage? Okay. And the next question we'll answer later is, can I lease a mortgaged property? These are the 2 questions we're going to answer, okay? So can we mortgage a leased property? Okay, the property is leased. It is theoretically possible. Yes, you can do this, but it does not occur practically. Okay, it is possible. Theoretically, it is possible. The property is called a leasehold property. When I own the property, it's called a freehold property. When I lease it, it's called a leasehold property. And yes, I can do it. And look at the logic. Virat Kohli is a lessee, and Rohit Sharma is the owner and the lessor. So Virat Kohli has leased this house. So he's staying in this house, he has leased it, and Rohit Sharma is the owner, correct? So can Virat mortgage his property? Yes, theoretically yes. Okay. Look at the logic now. Okay. So first, what happens? He has taken a lease from Rohit Sharma, and the lease is from 2020 to 2060. 40 years he has leased it. Okay. Now Virat Kohli wants to mortgage his property in 2030, 10 years after this. So there are still 30 years remaining, correct? So he wants to create a mortgage in 2030. So he goes to a bank. He has to give his lease documents to the bank. Okay. And in turn, the bank gives him 50 lakhs. And what is the due date of this mortgage? 2040, just 10 years later. And look at it logically. 2040 is well within 2060, correct? It is well within the lease period. So don't you think logically he should be able to do this? And the answer is yes, he can do it. Section 65D, okay, just states that when a mortgage is a leasehold property, when you create a mortgage out of a leasehold property, the mortgagee should accept the deed of the lease. So basically all the lease deed, the lease documents will be held by the bank. And when Virat Kohli pays it back, his right of redemption will be to get the lease documents back. Okay, but it doesn't mean, okay, I'll get to the complex part here, okay. Assume that Virat Kohli is unable to pay the money back. Usually what will happen, the bank will be able to sell the property, correct? They'll be able to file a suit for sale or foreclosure. But here, how can they do that? Because Virat Kohli does not even own the property, correct? The property is owned by Rohit Sharma. So what will the bank do to realize this money? Okay, let's say he has taken 50 lakhs from the bank and he's unable to pay it. And the lease period is from 2020 to 2060. Okay, and Virat is unable to pay it. And the date is also 2060. So the lease period is over. Okay, so now what is going to, who gets the money? What is going to happen now? Okay, there are two cases now, two things that could happen. First one, okay. First, the bank is desperate now because they can't file suit for foreclosures here. So the bank pays Rohit Sharma 20 lakhs or some amount to extend the lease. The bank pays the lessor or the owner to extend the lease so as to enable Virat to recover financially and repay the mortgage debt. They're hoping that if they extend the lease, Virat Kohli might somehow recover financially and be able to repay the debt. Okay, it's very atrocious, unconscionable, this whole situation. Just follow along. Okay, when Virat Kohli's financial situation improves and he ends up repaying entirely, let's assume after renewing it in 5 years he recovers and he repays the bank. The bank returns the lease deed, the documents, and registers an acknowledgement of repayment. Basically, his redemption happens. All the documents are returned to him. And now Virat becomes the leaseholder automatically until the end of the extension. Basically, the bank has extended it from 2060 to 2100. And in 2070, Virat Kohli repays the bank. So till 2100, he remains the leaseholder automatically. Okay. And in case 2, Virat Kohli himself renews the lease period. Okay, he doesn't have enough money to repay the bank, but he has enough money to extend the lease period. So he only pays 20 lakhs to Rohit Sharma and he extends the period from 2060 to 2100. The bank still has the lease documents. Okay, so Virat pays the lesser owner to extend the lease so as to enable himself to recover financially and repay the mortgage. Right? When Virat Kohli's financial situation improves and he ends up repaying the bank entirely, the bank returns the lease deed documents and registers an acknowledgement of repayment. So it's the same thing. It's just that in this case, the bank did it and now Virat Kohli is himself doing it. So what does section 65 say? Basically, we are going to see section 65. This is section 64. Okay, apologies. I just need to change this. This is section 64. All right. Section 64. Okay. Renewal of the mortgage lease. So when the mortgage property is a lease and the mortgagee obtains a renewal of the lease, where the bank is obtaining the renewal, the mortgagor upon redemption shall, in the absence of a contract by to the contrary, where the contract doesn't let him, he will have the benefit of case 1 is section 64. Okay, the benefit of the renewal will go to the mortgagor. The money is realized. Okay, after redemption, the benefit of the renewal will go to the mortgagor. Same thing. Section 71 is the diametric opposite case, where I told you about case 2, right? Many mistakes. Sorry, this is case 2. All right. So section 65 is case 1, section 64 is case 1, section 71 is case 2. Okay, when the mortgage property is a lease and the mortgagor Virat Kohli obtains a renewal of the lease, then the mortgage, in the absence of a contract to the contrary, shall for the purpose of the security be entitled to the new lease until redemption. As in, they'll be able to hold on to the lease documents until the redemption happens. Okay, the benefit of the leased property will go to the mortgagee, the bank, till the money is realized. So basically, the bank will be able to hold on to the lease documents till the redemption happens, and after that it will be returned to him. So in a crooked way, they both are saying the same thing. Basically, the bank will have the lease documents. Whoever renews it, either the bank or Virat Kohli, the mortgagee will have the benefit of the lease, whoever renews it. And upon redemption, section 71, they both are diametrically opposite. Now, what was the first question we asked? Can we mortgage a leased property? Correct? Can you mortgage a property which is a lease? So this is the second question, the opposite question. Now, can we lease a mortgage property? Like I had a house, I mortgaged it to Avinash, and I've taken 50 crores. Okay. Now, can I lease that property out? Don't you think of it logically? Now, when I'm taken 50 crores, I need to repay it, correct? And when I'm leasing it out, I'm getting some income, correct? And don't you think I'll be using that income to repay the mortgage? So yes, it is logical, correct? So yes, it is possible, and it is something that commonly occurs. That was theoretically possible and not practically occurring, correct? This is possible and it's commonly occurring, where you can lease a mortgage property. So the mortgagor might use the money from the leasing out of the property to repay the mortgage. Okay. If the mortgagee explicitly refuses to allow the mortgagor to lease the property in the deed only, if he explicitly states that you cannot lease this property, then the mortgagor can't do anything. He will not have a right to do so. And section 65A talks about this. Okay. We come to, okay, let's say Virat Kohli has taken 50 lakhs. He has mortgaged this property, this house to Rohit Sharma. And now the due date is far away. Okay. He wants to get some money back. He wants to get some income. Okay. So he leases this property to Hardik Pandya. So what he makes a lease deed with Hardik Pandya. Hardik Pandya pays him a small amount, 20 lakhs. He'll use this 20 lakhs to repay some of the mortgage debt. So it's all pretty much valid. That's all I want you to know. Okay. So what does section 65A state? Basically, we saw section 64 and 71. Okay. They talk about auto renewal of leases in mortgaging of leased properties. Now we come to section 65A, where we talk about leasing of mortgage properties. Okay. It's confusing, but don't worry, it's very simple. So what does section 65A talk about? All the restrictions on a mortgagor when he wants to lease a property. Okay. What are the restrictions? It has to be in accordance with local law, customer usage. Simple. Every such lease shall reserve the best rent possible. Like he can't just scam the person, right? You can't something that where the rent should be 100 rupees. He can't take 1 rupee for it. It has to be the best possible rent that he can get. Okay. No such lease shall contain an auto renewal clause. Correct? Because in case he's unable to pay the money. Okay. In case Virat Kohli is unable to pay this 50 lakhs to Rohit Sharma, and Rohit Sharma has to file a suit for foreclosure or sale, Hardik Pandya cannot be in the property. Correct? So you cannot have an auto renewal clause on this property. So Hardik Pandya cannot keep renewing the lease and continue to stay in this property. Okay. So it cannot have an auto renewal clause. The lease shall take effect no later than 6 months from the date on which it's made. In the case of lease of buildings, if it's a building, okay, the lease deed cannot exceed 3 years. This is a condition. Okay. And it also says that the right of re-entry will always remain. Nothing to break a right. Re-entry means when I'm leasing a property to someone, I'm leasing to Krishna and I find out Krishna is not taking care of the house properly. I have a right of re-entry where I can throw Krishna out and take over the house again. That's called the right of re-entry. So basically it's just saying that right of re-entry will always exist. Okay. So three points I want to make. If the owner, mortgagor or the lessor, owner he owns the property, mortgagor is borrowing the money, and as the lessor he's leasing it out also. So it's the same person. Okay. He sells the property to another individual. Okay. The mortgage debt will also be transferred to the new buyer. I'm selling, like I've taken a mortgage, I've leased it out also, and I'm selling this property to Anirban now. Okay. Now the mortgage debt will also transfer to Anirban. Okay. And the lease, he also becomes the lessor now. The new lessee has to pay Anirban now, the lease rent. Okay. Upon repayment of the mortgage debt. Okay. Let's say Anirban repays the mortgage debt. The title documents, the acknowledgement, and etc. Everything, all the blah, 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 all the extra part of redemption, according to section 60, right to redemption must be made to the new owner by the mortgagee. Okay. So what you see is happening over here. The right to redemption has been sold along with the property. This is known as the sale of the equity of redemption. Basically, section 60 has been sold to the new buyer. The new purchaser has purchased the right to redemption. Okay. So the right to redemption has been sold. That's what I want you to pick up from this. Because the new buyer gets the right to reclaim the title documents, the acknowledgement of payment, and the possession of the property. Correct. Coming to just this interesting concept of an infinite mortgage lease loan. What did I tell you? You can mortgage a leased property. And then I said you can lease a mortgage property. Okay.
Yeah, Vishnu.
Yeah.
Vishnu, another thing, if you can go back to 65A, the 65A actually, the major difference between 65 and 65A is basically for what Vishnu has also told, the leasehold property and freehold property. The other difference which is there is that there is no renewal clause in the 65A. If there is any covenant, if there is any contract per se, which spells out a renewal clause, then in that case, 65A tells that it cannot be possible. That kind of clauses cannot be put. And 65, there could be a contract which has a renewal clause. Yeah. And another thing is that in this kind of lease, which we are talking about, it will only take effect after the 6 months period.
Exactly, sir. Basically, what Samrat sir said is in 64, in this case, here with Rohit Sharma, he can have an auto renewal clause. That's all it says. Okay. And in 65A, you can't have an auto renewal clause. That's what Samrat sir just said. All right.
Exactly.
Yeah. So assume that the property is mortgaged, and then the mortgage property is leased to someone, and then that leased property is again mortgaged, and then that mortgage property is again leased, and it repeats 101 times. Okay. So A mortgages, A is the owner, he mortgages to X, the mortgagee, he mortgages the property. Then A leases it to B, the lessee. Then B, the lessee mortgages it to Y, the mortgage number 2. Okay, I have to change this to mortgage number 2. Just 1 second. Right. So A, the owner mortgages it to X, then A leases it to B, the lessee. Then B, lessee mortgages it to Y, mortgagee number 2. And then B lessee subleases it to C, the sublessee. Then the sublessee, he mortgages it to Z, mortgage number 3. Then the sublessee leases it to D. Can you see it's an infinite loop? And it's an endless cycle, unless as far as a contrary intention is not expressed in the mortgage deed or the lease deed. So if the mortgage deed or the lease deed tells that this property cannot be mortgaged or it cannot be leased, if it doesn't say that, you can continue doing this forever. Okay, it is a very disturbing concept. It doesn't happen. It's only theoretically possible. All right. So what is the reverse mortgage? It's a very fun topic. So it's a very unique kind of mortgage. It's a very specific kind of anomalous mortgage. So it's very unique, as in it happens only with old people or childless couples. Okay, a childless couple, they mortgage their property. They give their house as mortgage to avail a loan from the bank. In this case, they do not pay the bank any money, and the bank may in fact pay them a monthly allowance. Have you heard of this? Where the mortgagee is paying the mortgager after the mortgage also. But after upon their death, okay, since they don't have a child, and if it's a senior citizen who has no heir, then obviously, right, nobody will come to inherit the property. Upon their death, the bank will take over the entire property. Okay, so can you see that it's kind of a mortgage by conditional sale, except that the bank may pay them also for it, just to incentivize them to do this. So during the period of this mortgage, the mortgagor has no power to alienate the property. Obviously, right, they cannot sell it or lease it. So you cannot transfer this reverse mortgage to anyone else. It has to be held by them only. Because if you sell it or lease it and they have a heir or something, a child, then obviously the bank can't take over the property, correct? So they cannot sell or lease it. So it is at its core idea, mortgage by conditional sale. This is something Sir said. All right. So this is reverse mortgage. Just understand what it is. Don't break your head. Splitting of mortgage security. Okay. Can you take multiple mortgage debts? Can I create multiple mortgages on the same mortgage property? Yes. As in, I have a house. It's worth 100 crores, and I use it to take only 10 crores from Avinash. Okay. Or from Samrat sir, I take only 10 crores. Now, can I use that same property to take 10 more crores from someone else? Can I do that? Yes, I can. Okay. As long as the security, as long as the value of the mortgage property suffices, the mortgager can do as they like. Okay. Harry Potter, he has Hogwarts Castle worth 100 crores. Okay. He takes 15 crores from Dumbledore. He can do that. He mortgages Hogwarts Castle and he takes 15 crores. And now he wants more money. He wants 10 more crores. Okay. So he mortgages the same property for 10 more crores from Hermione. Okay. And then he wants even more money. Then he mortgages the property yet again for the remaining 50 crores from Voldemort. And is it possible? Is he able to do this? 15 plus 10 plus 50 is still 75 crores. So don't you think the borrowed money is still well sufficient? The security is enough to furnish. It's enough to furnish security for the entire amount, correct? So the mortgagees, in this case, they can come together and create a consortium amongst themselves and create a priority of charges based on the date of creation. Basically, let's assume Harry Potter is not able to pay it and they have to sell this property. So who gets repaid first? Based on the date of creation, a priority is created. So first Dumbledore will get the first priority, then Hermione will get it, then Voldemort gets it. All right. So he will be reimbursed first, then she will be reimbursed, then he will be reimbursed. All right. Now we come to a very complex topic. Just understand. Okay. Just keep along with me. Basically, what I say here, the mortgagee can do as he likes, right? With any property he wants. As long as the security is enough, he can do whatever he wants. Assume he has multiple properties. And even if he has multiple properties, he can split it like 50% of this, 50% of that, 20% of this, 80% of that. So assume he has 3 properties. Hogwarts Castle, he has a castle in New York, and he has a house in Spain. Okay, worth 150 crores, 100 crores, 200 crores. Now he wants to take 200 crores from Dumbledore, okay? And this property is worth only 150. So he offers this as mortgage property. He offers mortgages this property, and he mortgages Hogwarts Castle also, okay, to Dumbledore. And he takes 200 crores. Now when he takes 200 crores, 50 crores is remaining, correct? 150 plus 100 is 250. So 50 crores on Hogwarts Castle is still remaining. And he wants to take 100 crores from Hermione, correct? So he offers Hogwarts Castle 50 crores, and then he offers his house in Spain, which is worth 200 crores, correct? So he gets 100 crores from Hermione, okay? And what is remaining on this property now? 150 crores. So he offers that to Voldemort and he takes 150 crores. So I just want you to understand that you can do any kind of split possible with your mortgage property, okay? For you to create mortgages. So as long as the security of all the mortgage properties suffice together collectively, then the mortgagor can do as they like, all right? Internalize this concept properly because you need to know this perfectly for marshalling and tacking. Okay, I'm going to explain what they mean. Now we come to this concept where we come to the concept of marshalling. Okay, I'll go very slowly because even I might make a mistake in this. Okay, so there are three properties that Harry Potter owns: 150 crores, 100 crores, 200 crores. Okay, to take 200 crores from Dumbledore, he mortgages this property and Hogwarts Castle. Okay, so Dumbledore has a claim on these two properties. Okay. To take 100 crores from Hermione, he uses 50 crores remaining from Hogwarts Castle, and he uses this house in Spain. Okay, so Hermione has a claim on these two properties. These are common properties for her, and she gives him 100 crores and taking these two properties as mortgage. Okay, now Lord Voldemort remaining 150 crores on this, he mortgages it and he gets 150 crores. Okay, since mortgage number 1 was created first, Dumbledore will have the first priority, and Hermione will have the second priority since hers was created second, and Voldemort will have the third priority because his was created third. Priority of charges based on the date of creation. Okay, this is the premise, and now we'll come to the complex part as to what happens now. Okay, section 81. Basically, we saw section 58, the types of mortgages, section 60, right of redemption, section 64 and 71, or renewal of leases, section 65A, which talks about all the restrictions on leasing a mortgage property. And now we come section 69, where you don't have to go to court to sell. And now section 81, marshalling. Okay, so what is marshalling? Can the second mortgagee have any say in deciding what happens in the suit for sale of the first mortgagee? Okay, so in this case, Hermione, she has a mortgage of 100 crores and she has a security of the Hogwarts Castle, correct? Now she knows that Harry Potter has not been able to pay, correct? One second, why is this thing still on top? Can I? Cool. So Hermione, she wants to preserve the security on Hogwarts Castle, correct? Because when Dumbledore files a suit for sale, he will end up selling this house in New York, and he will also sell Hogwarts Castle, correct? To recover his money. But Hermione doesn't want her debt to be disturbed. She doesn't want Hogwarts Castle to be touched. Okay, so what does she want Dumbledore to do? She wants him to sell this property first before touching this property. And in case Dumbledore is able to get the value back, if he's able to recover his 200 crores by sale of this property, for some reason, some new buyer has come who's desperate to buy this property and he's ready to pay 200 crores for a 150 crore property. Okay, so she has the right to do something called file a suit for marshalling, where she insists that the common property not be sold first. Okay, as in what is the common property for both of them? Hogwarts Castle. She can insist that Dumbledore does not sell this property first and that he sells the independent property first to realize his amount. And in case there's a remaining amount, only then touch this property. Okay, that is called marshalling. Can the second mortgagee demand that the individual property be sold first and then only on requirement sell the common property of the mortgages? Yes, it is called a suit of marshalling of mortgage security. Okay, and the priority of charges is based on the date of creation. What does priority of charges in this case mean? Hermione can marshal Dumbledore. Okay, and Voldemort can marshal Hermione. Are you getting what I'm saying? Because the priority of marshalling is also created based on the date of creations. Okay, so in this case, Hermione can marshal Dumbledore to sell this property first. And in this case, Voldemort can marshal Hermione to sell Hogwarts Castle first because he doesn't want her to touch his property. All right, this is marshalling.
So basically, Vishnu, like Hermione has the right to choose, but the Dumbledore has the right to payment. That's what I are saying.
It's that Dumbledore has nothing to lose in this case. For him, he just has to get his money back, right? Yeah,
like you cannot have both. Either you can choose or you can like select a payment. Okay, so Hermione has the power to choose which property to be sold, while Dumbledore will realize the amount first. Hermione cannot do anything.
Money. Correct. Yes, perfectly.
Okay.
Use that rather than using the word payment, you say right to get paid first.
Yes. So whatever you feel. That's what I was just getting the concept. Like who has the power to choose and who has the right to like receive the payment.
At the end of the day, anyone who is having that particular property, I mean, who is actually responsible, the mortgagee who is responsible, he's the person to choose.
Yes,
Nobody.
like here
At the
in the
end of the day,
marshalling
it's like
order.
that only, but it's only a request which you are actually giving by marshal.
No, sir, it is not a request. It is legally binding.
It's a right.
This thing is
It's
legally
a right.
binding.
It's not a request. It's a right.
But then there is another thing, like even like for example, it should not. There is a clause, something like that, that it tells that you cannot actually ensure that somebody else's right is being intruded into. In the sense
Yes,
that,
that is also. Yeah, that is also.
So don't forget that also. I'll just, if you want, I'll just tell you exactly this thing, like what is the term that I want to actually talk about is that I'm talking about this one. Yes, that it should not prejudice the right of the prior mortgage.
Exactly, sir. You cannot do anything that prejudices the right of the prior, because the prior mortgagee is supreme always. He has the apex right.
It is also correct. It is beyond request. It is basically going via the decrees also. Yeah.
It is legally binding, but it cannot prejudice the prior mortgagee's right. Okay. So wait. So the priority of charges is based on the date of creation. Okay. So basically, Hermione can marshal Dumbledore. Voldemort can marshal Hermione. Okay. The right to marshal can be sold. I want you to understand this. So basically, if Hermione takes 100 crores from someone else, okay, and to me, as in I pay her 100 crores, then I become mortgagee number 2, and I have the right to marshal Dumbledore now. Okay, so the right to marshal can be sold. All right. So okay, look at what happens here. Okay, Hermione can insist on selling of the independent property, and only if any outstanding amount remains, only if it remains, then sell the common property. This is called marshalling of mortgage security. So Hermione, I'll explain it slowly again. Okay, Dumbledore has these two properties as security. Okay, so he wants to sell both the properties to get his money back. But Hermione also has these two properties as her security. Now she realizes that Hogwarts Castle is a common property and she wants to hold on to the security. She doesn't want it to be sold first. So she can file a suit for marshalling and insist that Dumbledore sells only the independent property first. So he sells this house in New York first. And in case he's able to recover the whole amount, leave Hogwarts Castle alone. Okay. In case he's not able to do it, only if he doesn't realize the whole amount, then he can touch Hogwarts Castle. Similarly, even Voldemort, since the common property is his house in Spain, he doesn't want this house to be touched because he doesn't want to ruin his own security. Okay. He can marshal Hermione saying that Hogwarts Castle has to be sold first, and only if the amount has not been realized, only then touch the house in Spain. All right. Subsequent mortgages are called puny mortgages. This is the term. Okay. Who are the subsequent mortgages? Hermione and Voldemort. Who's the prior mortgagee? Dumbledore. Okay. We come to section 91. Okay. I want you to remember this case because we'll come to this in tacking. Basically, we have built a stage, okay, to understand section 93. Basically, everything I've explained, from where Harry Potter splits his castle to where these guys are marshalling, all of this is to understand section 93. If you can understand section 93, you've understood mortgages. Okay. So we'll come to section 91. Who all have the right of redemption?
Vishnu, you never mentioned why when the marshalling doesn't happen. Can you mention that?
When does it not happen?
When there is a contrary intention takes place, the marshalling doesn't happen.
That is, okay, I've not mentioned it, but unless, obviously, right, if in the mortgage agreement, while making the mortgage agreement, okay, I think I've included later on in the mortgage agreement of Harry Potter, he puts a clause that this Hermione does not have the right to marshal, okay, because Dumbledore is threatening Harry Potter. He's like, you better put this or I'm going to put you in trouble. So Harry Potter is forced to put a clause that Hermione cannot marshal. If he puts the clause, it can be taken away. Okay, the right to marshal can be taken away. It again goes back to this part where I said that only section 60 is sacrosanct, correct? But how many sections have we finished? Yeah, only section 60 is sacrosanct. Every other section, 67, 68, foreclosure, money suit, compensatory suit, 81, marshalling, everything can be taken away by contract. If it is put in the mortgage agreement, if unless it is said in contrary to that statement, if it is said that the person does not have marshalling right, it can be taken away. Only section 60 cannot be taken away. Okay, so marshalling can be taken away. Purushothaman, good you pointed that out actually. I think I've put it in the slides. Let's see. So where are we now? Yeah, section 91. Okay, who all have the right to redemption? Besides the mortgager, any of the following persons may redeem. So what is redemption? Again, a quick recap. Section 60, the right to repay the mortgage and the right to get back the title documents, the possession of the property if it's not in possession, and an acknowledgement of payment. So who has the right of redemption? The mortgagor, correct? Who else has it? Okay, understand this concept. Any person who has an interest or charge on the property. Basically, this is a very wide ambit, okay? And it's very difficult to understand what this exactly means. Any person with a charge on the property could mean anything. Basically, Bhuvan is the mortgagor and he has a right of redemption, right? I'm paying him money, or I'm giving him some unsecured debt. I'm giving him some money, okay? And I have a right. I don't know how to explain this, okay? Because even sir did not explain this in class. Any person who has an interest in the charge on the property, I'll explain the other two, and based on those two, I'm sure you'll understand the first concept also, okay? The second one, who else has the right of redemption? Any surety. Basically, when you're taking a loan, haven't you heard of this? The mortgagee will tell, okay, you mortgage that property, but I want someone to stand as guarantee. I want someone who stands as a surety. Any person who stands as the guarantor for the payment of the mortgage debt. So let's say my dad is standing as the surety for my mortgage debt, okay? And I'm unable to pay it. So my dad ends up paying the whole amount, okay? All the title documents, all the mortgage documents will go to my dad. So my dad has got the right of redemption, okay? So any surety who ends up paying the mortgage debt ends up getting the right of redemption. So any surety for the payment of the mortgage debt or any part thereof will have the right of redemption. That's what I'm trying to convey. Third one, I'll explain with an example. Any creditor of the mortgagor who has in a suit for the administration of his estate obtained a decree for sale of the mortgage. Forget all this, okay? Just remember any creditor of the mortgagor. Basically, you're the mortgagor. I've mortgaged a property and I borrowed more money from someone else. So don't you think they have some kind of claim on that property that I have? So let's see this example. Virat Kohli takes 50 lakhs, mortgages his property to Rohit Sharma. Okay, and in the meanwhile, before this has happened or during this or after this, he has taken 20 lakhs from Hardik Pandya and it's an unsecured debt. He has not mortgaged any property. He has not given title deed. He has not given a surety, nothing. Hardik Pandya has given him 20 lakhs. Okay, so how will Hardik Pandya get his money back? He can file a money suit. Okay, so when the property is sold under section 67, let's say he's not paid even Rohit Sharma and Rohit Sharma files a suit for foreclosure sale and he sells the property now. So under section 67, when the property is sold, Hardik Pandya has a claim to recover the money out of the property after compensating Rohit. So after the remaining amount is compensated to Rohit Sharma, Hardik Pandya has a claim on whatever amount is remaining. Okay, let us say that Rohit Sharma has not claimed a suit for sale. Okay, since the limitation period is 12 years, Rohit Sharma is like, okay, I'll do it after 10 years, and he's not filed a suit for sale. And in the meantime, Hardik Pandya decides to file a money suit to recover his 20 lakhs. Okay, because of this, Hardik Pandya obtains not only a secured claim of the 20 lakhs. Okay, not only he gets the claim of 20 lakhs, he also gains full control of the administration of the property. He gains a ternary control of the property. He obtains a right to redemption of sir. These are the exact words used by sir. And according to what sir explained, he said that Hardik Pandya will have complete administrative right over this house in case he files a money suit before this guy files a suit for sale. Okay, don't try to break your head too much. I don't think section 91 is even coming. So basically, these are the people who have right to redemption. Okay, even I have not fully understood this, so don't ask me doubts. That's all I'll say. Okay, coming to section 92. Why you need to understand section 91 is just to understand part 2. Okay, anybody who compensates, anybody who pays the mortgage debt gets the right of redemption. Okay, section 92, what does it state? It talks about something called subrogation. Okay, a co-mortgager or anyone, actually anyone, in fact, let's say it's a co-mortgage who pays the mortgagee. Okay, as described in section 91. Basically, we have said, right, any surety or someone who repays the mortgage debt, he gets the right of redemption. So in this case, any co-mortgager or anyone, if he pays the mortgagee. Okay, he gains all the rights of the mortgagee. He steps into his shoes. I said, right, all the documents will go to my father, right? Because he gets the right of redemption, and the mortgagee passes all of it to my dad, and my dad technically becomes an ostensible mortgagee. Correct? He becomes the mortgagee technically. He gains the right to foreclosure sale, martial, and also the right to redemption. Perfect. I'll just give it to you with this example. Dumbledore, he has created a mortgage on these two properties. He has taken 200 crores. Hermione has created a mortgage on these two properties and she has given him 100 crores. Voldemort has taken a mortgage this property, has taken this property as mortgage, and he has given Harry Potter 150 crores. Okay. Now, Voldemort, he's the co-mortgager, correct? He's a subsequent mortgager. He wants even Hermione's claim of these two properties. He wants to get hold on these two properties also. So what does Voldemort do? He pays mortgagee number 2, the amount, the debt of mortgage 2. Okay. So he pays 100 crores himself out of his own pocket. And what happens here? Voldemort pays Hermione debt of mortgage 2 and therefore steps into the shoes of mortgagee 2. Okay, so what is happening here? This is called subrogation, where when a co-mortgager or anyone, in fact, pays another mortgagee their amount, then they will step into the shoes of that mortgagee. So Voldemort is basically mortgagee number 3 as well as mortgagee number 2 in this case. Okay, this is called subrogation. All right. In case I repay the debt, I pay 100 crores to Hermione, then I become mortgagee number 2. Even I am getting subrogated, and when that happens, I get the right to foreclosure sale these two properties. I get the right to marshal. Basically, whatever Hermione can marshal on Dumbledore, I can marshal, and I also get the right to redemption. Basically, all the property title documents that she has will come to me now, Harry Potter's. Okay, this is called subrogation. Now I want you to combine all the concepts from marshalling to subrogation to section 91 to come to section 93. This is the finale. Okay, this is the crown jewel of mortgages. Tacking. Okay, it's very interesting also. So when mortgagee number 3 has redeemed mortgagee number 1's mortgage, okay, that means where Voldemort has redeemed Dumbledore's mortgage. Okay, I'll explain why he'll do this also. Then mortgagee number 3 stands in two capacities. I told you, right? He's mortgagee number 3 and he will also become mortgagee number 1 because he'll take over the shoes of Dumbledore. Okay, as a mortgagee with respect to M1, with respect to the mortgage debt 1, and he'll be another mortgagee with respect to M3, his original debt. Okay, his right with respect to mortgage number 3 will not gain priority over mortgage number 2 just because of his subrogation to number 1. What does that mean? Let us say Voldemort, he has his mortgage number 3, he has given 150 crores. Now he has seen that, wait, 1 second. In this case, okay, it's slightly different. This house in New York, the house in New York is a part of the mortgage debt of Dumbledore as well as Voldemort. Okay, so Dumbledore has mortgaged the house in New York and Hogwarts Castle to give 200 crores. Hermione has mortgaged Hogwarts Castle and this house in Spain for 100 crores. Okay, and Voldemort in turn has taken the house in Spain and the house in New York. It's a very complex division of properties. Okay, and he has given 150 crores. So now what does Voldemort want? He wants to hold on to these two properties. Correct. Now he knows that Hermione, because she wants to preserve Hogwarts Castle, because that is her common property, she will marshal Dumbledore to sell the house in New York first. Correct? Very simple. I'll go slowly. Hermione has the right to marshal. Correct? She will marshal Dumbledore to sell the New York property first. Correct? But Voldemort is also having security on this property. So Voldemort does not want this property to be sold first. So how will he subvert Hermione's right to marshal? Okay? So he tries a very wily twisted plan. Okay? He pays Dumbledore 200 crores. Okay, and he becomes mortgagee number 1. Okay, so he becomes mortgagee number 1 by subrogation, and he thinks now that he became mortgagee number 1, can he subvert Hermione's right of subrogation, Hermione's right to marshal? Let's see. Okay, so his status as M3 will not get elevated to that of the prior mortgagee. What is it saying? It's saying him being M3 will remain as M3, and him being M1 will remain as M1. They both are independent of each other. Okay. Only with respect to M1, mortgage number 1, he will gain priority. But his own mortgage, M3, will not gain any such priority. And the debts will remain two independent standalone debts. What does this exactly mean here? So Voldemort pays M1, takes the shoes of mortgagee 1, along with their right to redemption, foreclosure, sale, all that nonsense. Okay. So he pays Dumbledore. He becomes mortgagee number 1. And now it does not mean that he subverts Hermione's right to marshal. Okay. Hermione will still have the power to marshal because she is still mortgagee number 2. Okay, she can still marshal Voldemort now in his capacity as mortgagee number 1 to sell this property because that is an independent property and this is the common property. So she can still, so Voldemort, by paying that 200 crores, he has achieved nothing. That's what I want to say. He gains no priority of charge on the third mortgage by doing so, because he thinks that by doing this, his right to marshal as the third mortgagee will supersede the mortgagee number 2. Okay, but that does not happen. He gains no priority of charge on third mortgage by doing so. Both the debts will still be treated differently. So Hermione's right to marshal will remain. Okay, that's what I want to know. Is this clear? Because it's very complex. Any doubts? I can explain it again.
Once more, man. The last section once more.
Yes. One more time, very slowly. Okay. Basically, we are combining all the sections we have learned till now. Okay. Very simple. So what happens here? Dumbledore has mortgage on these two properties, the house in New York and Hogwarts Castle. Okay. And he gives him 200 crores to Harry Potter. Harry Potter is such a scammer, man. He's taken money from everyone and has left everyone in the lurch. So Dumbledore gives him 200 crores. Then Hermione comes in. She has a deposit. She has security on Hogwarts Castle and the house in Spain, and she gives Harry Potter 100 crores. Okay. Now Voldemort comes in, and due to some peculiar division of properties, he takes the house in Spain and also the small remaining part of the house in New York, and he gives Harry Potter 150 crores. Okay, I'll put his photo here. So even he has a hold on this property. So now, according to the right of marshalling, who all have the right of marshalling? Hermione, the subsequent mortgagees, correct? Hermione has a right to marshal. She doesn't want Hogwarts Castle to be touched, correct? Because that is a common property. She doesn't want this to be touched first because she wants to retain her security. So she can marshal Dumbledore to sell the house in New York first. Okay, very simple. Now, what is Voldemort's right to marshal? He doesn't want this property to be touched, so he can marshal Hermione to sell Hogwarts Castle first. But Voldemort is in such a peculiar situation that he's screwed either way, because even if he makes sure Hermione doesn't touch this, Dumbledore will end up touching this. So Voldemort wants to subvert Hermione's right to marshal. He wants his right of marshalling to supersede hers. So he tries a very twisted method where he tries to subrogate. He tries to do section 92. He tries, by the means of subrogation, he wants to take a mortgagee 1's place. Okay, so he repays mortgage debt 1. So he pays 200 crores to Dumbledore in order to become mortgagee number 1. Okay, so what happens? By subrogation, he becomes mortgagee number 1. So he has security on these two properties and he has security on these two properties. So technically, he has some sort of security on all the properties now. So he thinks his right to marshal will supersede Hermione's, and so Hermione will not have the right to marshal. So she cannot insist on selling this property. Okay, so that is his plan. But what happens? He gains no priority of charge on the third mortgage by doing so. He's the first mortgagee now, no? So how will it happen? The first mortgagee has to recover his money, correct? He can file a suit for foreclosure or sale. He has to sell either of these properties. Now, since he's on scammer, he'll try to sell Hogwarts Castle, but he can't do that because Hermione has a right to marshal. So she will marshal. She will tell you have to sell this property first, and he sells this. So are you seeing what is happening? Him becoming mortgagee 1, he becomes only mortgagee 1. It leaves mortgagee number 3 status independent. Okay, that is not going to be affected. So as mortgagee 1, he can file a suit for foreclosure or sale, and he has to sell either of these properties, and that is subject to the marshalling rights of Hermione. So he has not been able to accomplish anything, and this is called tacking. So this is prohibition of tacking. Voldemort attempted to do tacking, but section 93 prohibits it, where it says that you will not gain priority, and the two mortgages remain two standalone debts. That's what it says. This is prohibition of tacking. Okay, is it clear?
Bhuvan, what Vishnu is only telling is that the mortgagee number 2's right will remain as it is. That will
100%
never
clear.
be
So basically,
independent.
So basically, tagging essentially is the effort on part of one mortgagee to gain another one's place, where he can basically,
Exactly.
he
Get
can
it
basically
priority.
club
Get
his
it
two rights.
prioritized.
He can club his two rights, but he would still not be able to. Mortgage number 1 would remain as it is, 3 would remain as it is, and Hermione will still have right, on the third one. He can still
Perfect,
not
perfect,
supersede Hermione, right?
perfect, perfect. But here, remember, Bhuvan,
Yeah.
what you're telling that the right over property is not the main thing, right? Over the prioritization. That is the
Prioritization, yeah.
point that we are talking about. See, basic idea
Prioritization.
is that he's actually paying that building, and then and he does not get for that building only. He's getting the priority. For
Absolutely, absolutely.
got my point?
He's
Yeah,
getting priority only for the New York house, right? Yeah.
exactly, exactly. The first one.
Perfect,
Vishnu,
perfect.
uh, I have a question regarding marshalling. Like in a sense, like Hermione get due date first before then, like property income. What is his name? I forgot. Like Dumbledore, actually, huh? He got due date before Dumbledore. So Dumbledore has the right to marshalling or not? The same problem, the same trivia, like came into the class, and we had no answer for this.
Exactly, Krishna.
I have the answer for that also.
There is no solution for that one. See,
No, sir
this
gave
is
a
the
solution.
doubt.
Sir said you can file a compensatory suit under 68(1)(c). Sir gave the solution for that.
Yeah, yeah. Solution is that one has been given, but then again, he later on told that that may not be a solution also.
Okay, so I didn't want to bring that
Yeah.
because it's already so complicated, this whole topic. I didn't want to make it even more complicated. Okay, so look at this case. Okay, if this idiot had just repaid Hermione and he had subrogated to become mortgagee number 2, then he could have marshaled Dumbledore to preserve this property, correct? Are you getting what I'm saying? Instead of trying all this circus, if he had just paid 100 crores to Hermione, he would have become mortgagee number 2, correct? And he could have stopped himself from marshalling. Are you getting what I'm saying? Instead of doing all this circus of paying Dumbledore, he could have become mortgagee number 2. That's all I'm saying. Okay.
But that provided the mortgage number 2 wants to.
Yes, mortgagee number 2 has to accept. Perfect. So coming to the last concept is very simple. Don't break your head. Gifts. Okay. So what are gifts? it comes under section 5 of Transfer of Property Act. So gifts where I want to give something. So why gifts come into picture is when I'm selling a property, okay? In Bangalore, at least in Karnataka, Bangalore, to register the sale deed and the sale agreement, it's around 7%. So if I'm selling a property of 1 crore, the sale deed itself will cost me 7 lakhs. So what do people do to overcome this 7 lakhs they have to pay? They end up gifting properties, okay? Because in gift, you don't have to pay such a large tax. So gift is where you give something. I want to give my water bottle to Bhuvan. I want to give my mobile phone to Samrat sir. It can be movable or immovable, okay? Movable as in mobile phone, water bottle, bike, car. Immovable as in property, okay? So section 122 defines a gift. Gift is a transfer of certain existing movable or immovable, like I said, property made voluntarily and without consideration. Consideration from contract law, where they're not paying me anything. It's completely free out of love and care, okay? Out of kindness, by one person called the donor to another called the donee, and accepted by or on behalf of the donee, okay? Acceptance when to be made. Such acceptance must be made during the lifetime of the donor, okay? If the donor passes away, then the gift is void. If the donee has not accepted yet, okay? So the acceptance has to be made during the lifetime of the donor. But the donee can take 20, 30 years, 50 years. As long as the donor is alive, they can accept it whenever they want, okay? And while he's still capable of giving, obviously. And if the donee dies before the acceptance, obviously the gift is void, because who will you be giving the gift to? So section 25 of the Indian Contract Act says that any agreement without consideration is void, okay? Unless it is made on account of love and affection between the parties standing in near relation to each other. So section 25 is not violative of gifts. Section 122. That's what I want to bring in, okay? Gifts of immovable property must always be registered. So basically when I'm gifting a car, house or a property or a site or a shop or a bungalow, then it must always be registered, okay? A gift of movable property need not be registered, but I might do it also. I don't have to, but I may do it. Mere delivery is enough. What is delivery? If I hand over my phone to Bhuvan, it's a gift. That's all. It's done. Okay. It's a very shaky thing actually when you see it like that, but okay. So it has to be inter vivos. Okay. What does that mean? Between two living beings. Section 5 of the Transfer of Property Act states that gift can happen only between living people. Okay. It's not between a dead person and living person. It's not a will. Okay. Gift requires an acceptance from the donee, like I said, and if this acceptance is not conveyed within the lifetime, the gift is not operated. Simple. And suppose you're registering the gift deed, okay? Suppose you're registering it according to section 123. It states that the last page of the gift deed will have the donee, along with his acceptance, he has to put his signature, and attestations of 2 witnesses. This is from section 123. I shall put it here, okay? Then the donor can go to the registry office in case of a registered gift, and without the donee doesn't have to come, and he can make the gift. He can get it registered, and the donee can make the acceptance whenever they want, 10, 20, 30, 50, 60 years. He wants, but within the lifetime of the donor. Basically, I'm just giving extra points to make this even more clear. Okay. Section 123 talks about registration of gifts. Okay. It deals with all registered gifts, both movable and immovable. I said immovable has to be registered. Movable does not have to be registered. It may be registered. Maybe I'm gifting a very expensive car. So just for safety, I will register it. Correct. So gift of immovable property has to be made by a registered document. Immovable property may be delivered, and delivery is enough. And the registered document is not necessary. And what have I written here? It may still be registered. Okay. Gift mortis causa. It's very cool sounding, no? So what is gift mortis causa? It means gift made in contemplation of death. Imagine some old person is contemplating death. They're on their deathbed. Okay. And then they make a gift at that point. Section 129 of Transfer of Property Act. What does it say? It says that saving of donations, mortis causa, gift mortis causa, and Mohammedan law. Nothing in this chapter reflects to gifts of movable property made in contemplation of death, gift mortis causa, shall be deemed to affect any rule of Mohammedan law. Basically, it's saying that any gift made in gift mortis causa or any gift made under Muslim law does not apply. Like all these rules, all these sections 122 to 128 don't apply to Mohammedan law and gift mortis causa. Okay, so which section do we see for gift mortis causa? You see Indian Succession Act. Okay, section 191 of the Indian Succession Act talks about gift mortis causa. So what is gift mortis causa? Gift made in contemplation of death. It's when a person provides a gift to another because they believe they will soon die. Okay, it is not affected by Transfer of Property Act. Section 129 states that, but it's controlled by ISA. Okay, this type of gift, unlike a transfer via gift or inter vivos, is revocable by the grantor unless they do pass away. What does that mean? As in, this is an old person, he gives me something, okay? And let's say he recovers, like he had an illness and he recovers, okay? And at that point, the gift becomes void again. He can take it back. That's what it means, okay? So what does it say? It is inter vivos, okay? It can't happen between a dead person and a living person. Both have to be alive. It's just that the owner is in his deathbed, about to die, okay? Deals with movable property alone. I want you to remember this. Only movable things. My watch, my ring, my bike, my car. If the transfer wishes to gift an immovable property, deathbed or not, whether that person is going to die or not, the only method is through Section 122 of Transfer Property Act. Section 122 is gifting, basically what I told you, gift defined, okay? And they have to register it according to Section 123, okay? The donor and donee need to be alive during the time of the gift. It has to be inter vivos, okay? If the donee dies before the donor, as in the person receiving it, then the gift will not take place. Obviously, right? Who will receive the gift then? And if the owner recovers from death, then also the gift will not take place, okay? So it only depends on death. Only if the death happens, the gift is permanent, okay? If the person in deathbed gets it registered formally with witnesses. Like I said, it's only movable property, and movable property does not have to be registered. In case the person in deathbed wants to, like out of all, like he goes through every enormous effort to get it registered formally, where he calls a registrar office, like the registry to his house. He calls witnesses, he calls an advocate. Then it will come under Section 123 of the Transfer of Property Act. It won't come under 191 of Indian Succession Act, okay? If he gets it registered formally, then it is 123. Because 123 talks about registration. At that point, it stops being gift modus causa. Okay. So I gave an illustration. Donor is in his deathbed. He makes a transfer by registered document. So he registers it. Okay. Now he recovers. And if it was gift modus causa, if he recovers, the gift becomes void. Correct. But he has already registered it. Correct. Once he registers it, it becomes Section 123 and not Section 191. Okay. Now he recovers. Can he reclaim the gift? No. When a registered deed exists and the donor recovers, there will be a conflict of 191 and 123, and which supersedes 123 because the registration has happened, right? So the donor will say that under 191 I've recovered, so I have to get the money back, and the donee will say that under 123 the delivery has been done under registered deed, so it's done, okay? And what Sir said is the case could be decided by establishing the contemplation of death, all the conditions that have happened, and to what is the contemplation of death exactly? And he said, read the illustrations of 191. I've listed them here. Let's have a look at it. Okay. So basically, this is one of the illustrations. So what I say under gift modus causa, only movable property, correct? So when I give a key of a warehouse to someone, I give the key of my grandfather gives me the key of a warehouse. Okay. And he passes away. At that point, the warehouse does not become mine because the warehouse is movable property, immovable property, correct? The constructive delivery would be the goods in the warehouse. Everything that is in the warehouse will belong to me. Okay, and not the warehouse itself, as it's an immovable property. If the key is to a trunk, like some suitcase, then the person will be entitled to the trunk as it is a movable property. Okay, this is one of the illustrations. What are the illustrations of 191 Indian Succession Act? So A being ill, the person who's on his deathbed, he delivers to be a watch. Basically, they're listed out different things: a bond, a bank note, and a promissory note. Okay, and A dies of illness. And in this case, B is entitled to all of them. All of them are valid gifts because they're all movable properties. Okay, so B is entitled to all of them. Okay, this is the first illustration. Second one, A being ill, contemplating death, he gives the key of a trunk, like we discussed. B is entitled to the trunk, and same way he gives him the key of a warehouse, and A is entitled to the goods of the warehouse and not the warehouse itself because the warehouse is immovable property and the goods are movable property. Okay, third illustration, A contemplating death, he puts certain parcels, some articles, and he wants to give it to B and C. Okay, he wants to gift a certain movable components to B and C, and the parcels are not delivered during the time of A, during the life of A. A has passed away and the delivery has not happened. I want you to remember that for movable property, delivery is enough, right? You don't have to get registered, but delivery itself has not happened. That means the gift has not been accepted yet. Okay, so the parcels have not been delivered and A dies of illness. So B and C are not entitled to the contents of the parcels. Okay, so these are the three illustrations in the Indian Succession Act. So based on this, if it gives you any case, you can identify whether it is 123 or 191, gift modus causa or a normal gift. Okay.
Can you just explain the point?
Which one? Which point?
The last one I think you made.
Last one is very simple. What gift modus causa is only for movable property, correct? And for movable property, what did I state here? I said movable property, it need not be registered. Mere delivery is enough. The second it is delivered, acceptance has been made. I'm delivering this pen to Piyash. The second it reaches Piyash, acceptance has been made. Gift is done. Okay. So here he's transferring the movable property. He's gifting some parcel to B and C. And the parcels are not delivered during the life of A. A dies before the delivery only. And no registration has happened under Section 123. Okay. No delivery has happened, so the gift has not been accepted, and A dies. So B and C are not entitled to the contents of the parcel because the gift becomes void. Simple.
Vishnu,
Yeah.
Here you have mentioned if if the parcels have not been delivered during the life of A, right?
Yeah.
Say the parcels got delivered. I know it's a very hypothetical situation, must have also been raised in the class. Say the parcels get delivered just at the time of death,
Yeah.
or on the day of death, like it's like just 1 hour difference or so. Would the real rule of equity not apply there?
Rule of
And
equity.
and also, I mean, let's leave equity on one side. Sorry for bringing that in, but at the same time, I mean, can we not apply that post box rule? It's beyond the power of the person who is sending to get it back now. Who's already sent it.
No, man, because postbox rule doesn't come here because that person might choose not to accept it also. Suppose he's sending me a bomb. Okay. I don't want to accept it. So why will postbox rule come into play? Come into play only when I get it, right?
Moreover, that is related to contracts. Like, I don't think it will be applicable very much here.
No, the principle, yes, I get what Bowen is saying because it's out of the power of the. Yeah, I got it.
Yeah, I get the spirit, but I think it will it will be struck down based on legal.
No, man, Bowen, it doesn't have to be a bomb, okay? Like my uncle is giving some diamond ring to me, okay? But I don't want to accept it because I really like my cousin, like his own son, and I want the son to get it. So I'll refuse the acceptance of the gift so that my cousin gets it. Okay. So in this case, I've not accepted it, correct? So for me to make that acceptance or rejection, I'll have to get it myself. That's my argument. Is that clear, Bowen?
Yeah, okay.
All right, that's it then. We're done.
Yeah, thank you, Vishnu, for such an elaborate presentation. I think I don't need to study anymore.
Fantastic. I'll share the PPT on the group. All right.
Yeah.
So
thanks a lot. Any word would not be enough. How much time did it take you?
It's been a long time effort, no? Like from the start, I've been doing this. So it's all right. Okay, so you guys want to see 53, 35? No. I think sir will ask from this. Don't you think the syllabus is so large that he can't put in questions from test 1 and 2?
Yes. I also think like he will specifically let us concern himself with the most important ones.
Yeah.
How many marks is it? Like this time 25, 30? I'm not sure though.
Should be 20, 25. I think it's 25.
25 में क्या करेगा यार? 2-3 क्वेश्चन ही डालेगा.
Tacking only you can give for 25 marks, I think. Like if you give a proper case study.
Yeah, I think then so really concentrate on the most important parts. Okay. In jurisprudence, I also did that. I left out the first answers completely, and like I got lucky. So okay, anyway, the syllabus is very large. Yeah, thank you, Vishnu. Thank you very much. Cool, I think the rest of the class also feels the same about it.
Yeah, sure. See you guys then. Bye. All the best for tomorrow.
Thank you, Vishnu.
Thank you.
Thank you, Vishnu. Thank you, Vishnu. Bye-bye.
Thank you.
Thank you, Vishnu.
Thank you, Vishnu.